Well, thanks everyone for joining us today for this webinar on 20 years of defending digital ownership. So I would say some of the basic assumptions of copyright policy, particularly when it comes to user rights, were the result of the way that copyrighted materials were distributed to the public on physical copies, books, CDs, albums, VHS tapes. And of course, many copyrighted works are still distributed that way, but many aren't. There have been famous instances of publishing houses attempting to limit what people can do with copies of works that they have purchased. In the Bobbs Merrill case in 1908, the Supreme Court held that you can't just slap a not for resale sticker on a book to control the secondary market, which is a term you might hear in this panel a lot. It just means the used market. And in 2013, in the Kurtzeng case, the Supreme Court also held that publishers can't prevent the importation of books that were initially sold overseas. And this distinction between the rights of authors and publishing houses, the rights holders, with respect to copyright, but then the rights of users and readers with respect to specific copies that they have purchased, I think has really served us well. But it's something that developed over time. I don't think it was ever planned. It just sort of fell out of the fact that people have certain expectations with artifacts that they buy, and then the law essentially backed up their instincts as to what they should be able to do and what they shouldn't be able to do. But in the digital world, we don't have physical copies of things that we can just freely move around, lend, and resell. And in fact, the contracts that people sign with the tech platforms and publishing houses and so forth over buying digital copies of works, well, they actually say that you didn't buy anything, you're just licensing it, which I think isn't an entirely legally coherent concept for what users are doing. And in fact, Apple is facing a class action lawsuit over this right now. But there you have it. So on this panel, I think we're going to talk about, what is it that people should be, what should the rights of users be with respect to digital ownership? Should there be a way for people to resell digital content that they have bought, or leave it to their kids in their will, or things like that? Should there maybe be a resale royalty? There's a lot of different options here. But I don't want to do all the talking today, so I'm going to introduce our panelists, and let's get started. So today we have Michael Weinberg, who is the Executive Director of the Engelberg Center on Innovation Law and Policy at NYU Law. Lila Bailey, who's a Policy Counsel at the Internet Archive, IP3 Award winner. Professor Lateef Mtima, Professor of Law at Howard University School of Law, founder and director of the Institute for Intellectual Property and Social Justice, and I believe also an IP3 award winner. They're everywhere. You can't swing a cat in this town without hitting an IP3 award winner. And Michelle Wu, retired professor of law at Georgetown University, who is not retired from her work in general, but no longer an academic apparently. Right, so there's my panel. And I'm going to ask the first question to Michelle Wu, and then after she answers, the other panelists can just sort of pitch in, and we'll just go like that. So Michelle, many activities in the analog world, such as just sort of lending books and reselling CDs, like I just said, that doesn't work with digital files. So how much of this are like actual restrictions that, it's not legally possible to do what consumer advocates like me want to do? Or is it really just like the business models of the publishers, or just like the market pressure? Would you maybe talk about that for a little bit?
Sure, so I think it's a combination of all of those. Obviously, there's some legal instruments that can be used with digital items that cannot be used with physical items. You've already cited the cases that have determined that publishers can't put downstream restrictions on physical items. But with print or with digital items, there are two different, legal instruments that can be used beyond what can be used with print items. And so to give you two examples, the first is contracting, and the second is the DMCA itself. So the first, in terms of licensing, with a digital work, publishers can actually replace ownership with rental. So if an individual who pays for access to a work never actually gains ownership, they also don't gain any of the rights that attach with ownership, right? So that's resale, that's preservation, that's interlibrary loan. All of those never attach because there is no ownership. The second example is the DMCA, which is, I would argue, it actually doesn't protect the interest of copyright. It doesn't protect a copyrighted work. What it actually protects are the technological controls that might be bundled with a copy of a copyrighted work. So what the DMCA does is it actually extends extraordinary protections to works under copyright that extend beyond traditional copyright law. Now, you asked if this is about the law, or is it about industry, or is it about market? And I think it's a combination of all of those, right? So obviously, I've just described some legal structures that can be used, but how those legal structures are used are determined entirely by the industry. And the industry will, or the industry has, justified some of their preemptive, restrictive actions that damage public use by saying, we're driven to this because our markets will be damaged otherwise. If we don't take these actions, if we don't use these license agreements, our markets will be damaged. And I think what troubles me about that is industry has proven to be very unreliable in being able to predict damage of new technologies. Take the Betamax case. So if you take a look at the news reports during that time, they claimed irreparable harm, mortal damage to their market. And we've seen since then that instead of damaging a market, it actually gave them more revenue producing options than they had beforehand. So hopefully that answers the question.
It does. Would anyone like to answer or respond? Because, so one further question I have, just from the sort of, the side of the argument that I might not usually take, is that, with digital files, though, okay, I buy a book, I buy a CD, and I can sell it, but it's like, it's limited, right? It's one copy. I'm sure you can make an unauthorized copy, but for the most part, that's not like necessarily a huge worry. If you didn't have DRM, if you didn't have the protection for DRM that the DMCA has, and if you had some sort of, what's to prevent someone from saying, oh yeah, I just sold this, but I'm just keeping a copy, right? So you can see, if you're from the perspective of like a rights holder, you're like, okay, you're just talking about you want to bring back for sale, that's fine and dandy, but how do you actually make it so that I continue to get paid when someone wants to buy something new, and that the copies of my work don't just, multiply through the back door?
Sure, so I have two responses to that, one of which may be very controversial. But the first is, copyright law already allows for infringement. So if someone has made more copies than a purchase, assuming that a vendor can track that down, they actually do have a cause of action within the copyright code already. The second comment I have is, I'm actually not against DRM. I'm against the DMCA, which is, those are two very, very different concepts, right? So if there were no criminal or civil penalties attached to anti-circumvention, if people could use a fair use argument to circumvent, just like they can for infringement, I would have no problem with vendors using DRM, because then all of the fair use rights that are given in the copyright code can actually be used. So I'm not saying that vendors can't use DRM, or that DRM is necessarily in and of itself bad. I just think the formulation in the existing code went a little too far.
Okay. And then, so I do have a question for Professor Mtima, which is, so basically, from the perspective of communities of color, marginalized groups, it seems like there's two conflicting, if you're a smaller creator, you're losing control, you might think, how do I control my work? How do I monetize my work? Digital technology makes everything so easy to copy, and it's so hard to control the use of works in the digital environment, because it is the nature of computers to just make copies of things. But at the same time, those same people want to use works, and they don't want to necessarily be locked out of, building on culture of the past. They don't want to, and anyone might want to own works and be able to resell them. So how do you sort of balance those two, those two different constituencies, or those two different perspectives on the of the effects of digital technology on copyrighted works?
Yeah, thanks, John. I think that's a really excellent question, because I think that as we wade through these issues and as the years go by, we come to the realization that small and independent artists, creators from marginalized communities, including communities of color, are sort of like caught in between a rock and a hard place on this landscape, because you're absolutely right. I mean, artists both create works and they use works. And interestingly, sometimes artists create by using works. And so they are really looking at it from both sides. And when you are from a smaller or marginalized community, the current landscape presents just an array of challenges. So first of all, just in terms of your make use of pre-existing works, today we have an availability problem. If you are used to focusing in on a particular genre or works that are of interest to particular groups or particular communities, increasingly some of that material is just simply disappearing from from public availability, simply because similar to, but not quite as much of a challenge as what we had in the analog world, if it ceases to become commercially viable to produce certain works, then those works just are no longer available. And if you're looking to a particular genres that really only are of interest or primarily of interest to smaller communities or marginalized communities, then much of that work may not find itself in digital formats. So your ability to access the material that you're most interested in, well, that becomes restricted. But then at the same time, right, when you put your work out, right, I would argue that the works of marginalized and other small and independent and just say out of the mainstream creators are especially vulnerable in this landscape because they're particularly unique, right? And once they are placed in digital formats, it's not just big corporate conglomerate owned works that is vulnerable, right? It's the individual artist's work who is also vulnerable. So if you're a small, non-mainstream creator, this brave new world is particularly onerous, right? You can't find the stuff that you would like to use. And then when you manage to produce your own stuff and put it out there, not only do you not have the tools to protect yourself, but because your work is particularly unique, right, then your work becomes particularly vulnerable and attracts more, let's just say, unauthorized use. And I tend to use that term because the thing of it is that not every unauthorized use constitutes copyright infringement, right? So it's a particularly difficult situation, I think, for both creators from marginalized communities and for those communities themselves.
So I'm going to go to Lila pretty soon on the availability point, but I do have a follow-up for you. So, traditionally, you had all these businesses whose whole purpose is to identify authors, musicians, so you have record labels, publishing houses, even retailers, bookstores. It's like they select, it's like, okay, of all the people out there, we've actually gone through and we filtered out who are the good ones. And then the retail stores, so you have this filtration process. So if you're left out of that, it's terrible, but it does mean that there is a path from being an artist to reaching the public. And I think it can, we all know that sometimes those intermediaries can be exploitative and they make people sign their rights away and everything, but still, it does provide this discovery mechanism. And it does seem, part of the issue with getting with copyright in the digital world is there's this wash of material because you can just go right from creating something to putting it on YouTube. How can we sort of replicate the sort of social structures that sort of did that, where readers would like also, they would rely on these other people to figure out who the authors who might be worth reading are, or the musicians who are worth reading. You know, they don't go through the slush pile by themselves.
Mhm.
Do you see that as being a problem too? Just this abundance of creative works, and how do you stand out? How do you get discovered in this mix?
Yeah, no, another good question. You know, one of the things that I have written about and have been very interested in is the way in which this model of a conduit of, you know, creators and then distributors in the middle, serving as the conduit to getting material to the public, which is what you just basically described, how that has evolved over the decades. You know, originally you had something more of a partnership between creators and the distributors. I mean, I'm thinking of, you can think of some old movies in which, you know, the author is sitting down with oh, this is my publisher, and they're discussing, you know, what the next book ought to look like, et cetera, et cetera. And of course, in the modern world, you don't see much of that. I mean, basically what originally was sort of like a linear conduit with the distributor in the middle evolved over time, such that the role and the power and the influence of the distributor just sort of rose above. And so what had been a linear relationship is now more like a pyramid, right? With the distributor dictating down terms to the author on one side and dictating terms down, dictating content down to the public. In other words, the top of the pyramid deciding, okay, well, this is what I think is commercially viable, right? And so this is the type of stuff, you know, that you're going to have access to. So sort of like that filter mechanism going awry, right? And I think that the answer to that, one of the things that I've suggested is that I think that creators should really start banding together. And now that distribution is real, digital distribution is really within the hands of just about anyone, right? I mean, you can digitize your stuff inexpensively, and if you began to get together, right, and distribute your material as a collective, then you would have the artists sort of determining, okay, what sort of material we want to make available to the public. And I think that whereas the initial concern might be, well, you know, how would an artist distribution model compete with the current model? Well, one, you have the cheaper cost. And two, the fact of the matter is that the principal advantage that traditional distributors have is a huge catalog, right? But if artists begin to band together and take over that role themselves, well, they will have, certainly they'll have the biggest new catalog, right? And of course, people will be responsive to the fact that, hey, this is the material that the artist has just put out, or this is the material that the artist herself is saying, this is some of my most interesting work, or these are the people who I listen to, and you may want to check them out. So I think that that may be an effective means to sort of evolve on the current landscape.
All right, thank you. Lila, so libraries. I think, again, we all know that libraries serve many functions beyond merely providing access to copyrighted works. So, you know, they're community centers, they help you, you know, they do all kinds of things. But nevertheless, one of the core purposes of libraries over the years, over the centuries, has been to allow people to access works. And not only that, they usually don't have to pay for them, right? So that's a little controversial sometimes, and it's sort of a pretty, many people observe that if someone came up with the idea of a public library today, it would be seen as some sort of socialist plot, but you know, they're sort of grandfathered in, so that's wonderful. So I guess I have two questions. So Professor Mtima brought up this issue of availability, and it seems that there's like two parts to that. It is sort of ironic but true that sometimes digital works become unavailable. And so that's something the Internet Archive does, preserving digital works. But there's another thing Internet Archive has done, which I hope maybe you could explain briefly, which is making print books that are otherwise not available electronically at all available. So how does the Internet Archive sort of handle those two things, in terms of like the legal considerations, and then maybe if you have any thought on, the question of like, what do authors think of this?
Sure. Yeah. So there's already been so much rich stuff. I would love to respond to everything Lateef just talked about. That so many interesting ideas there. On the availability issue, I think when I was preparing for this thought, I was thinking in particular about how the DMCA, so the Digital Millennium Copyright Act, the notice and takedown provisions, at least in terms of how the Internet Archive functions, that I think has actually allowed for more availability of what I would call the long tail, the weird, quirky, ephemeral, less commercially interesting and viable stuff, right? We have all kinds of really interesting user uploaded collections. One of them, which is just posted in the chat here, is our LibriVox collection, right? This is regular people that read public domain books, record the digital audio, and then submit or sort of put those things into the public domain. And we have this big collection of audiobooks that were created by regular people, right? Not through a commercial intermediary. We have a bunch of, we have old timey radio, we have old silent films, we have all kinds of non-commercially available things up on the Internet Archive, largely because the DMCA allows for users to upload those things, and for us as a library to host them without being overly, I mean, look, we are stressed out about this, but without being overly stressed out that if our users have made a mistake about whether it's commercially available, whether a rights holder really does care about this, we can rely on the rights holders to come to us and say, actually, I'm making use of this, please take it down. And then we do, right? So this has allowed a huge number of those, what would I think otherwise be basically digital orphans, like orphan works, right? That would disappear, have been able to be collected and preserved by the Internet Archive. So on the one hand, I think the DMCA has helped a bit with that long tail preservation. But what Lateef was talking about was this availability actually of commercially interesting stuff, right? That stuff is actually weirdly more likely to go missing or to be unavailable to people. So I think a really great example of this is from this year's Best Picture nominees for the Oscars, right? 4 of the Best Pictures were from some streaming service. And so you had to buy access to Hulu or Netflix or Amazon Prime or all of them, right? In actually to be able to watch all of those Best Picture winners, and none of those movies is available to a library in any form. There's no physical format that a library can buy, and libraries aren't offered a subscription model either. So libraries are completely excluded from the ability to purchase on the one hand, because the other thing is when we talk about library books and other things being free, they're free to the public, but they're not free to the library. Okay, libraries pay literally billions of dollars for content, for books, for audio, for everything. So let's not forget that these things are not in fact free. They are free to the end user, but they are not free to the library. And in fact, our taxpayer dollars go hugely into subsidizing this. So this idea that these things are free is really a bit of, it's not totally 100% accurate, right? But so this idea that the stuff that's actually commercially available is extremely restricted in our digital world is very counterintuitive to what we probably all of us sort of in the sort of 90s and early 2000s thinking like, oh wow, there's going to be this amazing abundance of everything because no scarcity on the internet, yay. But the market really has figured out how to recreate scarcity. That's actually been quite effective. And so libraries are really stuck in this position in the middle where the libraries are still trying to provide that access to anybody, regardless of whether you can afford to pay, regardless of your zip code, right? To be able to sort of equalize access to information, culture, and knowledge. But on the other hand, we're seeing publishers unwilling to license to libraries at any cost, right? Amazon recently has been criticized for this behavior exactly, right? Their audiobooks and their own Kindle imprints are not available to libraries at any cost, not for sale, not for license. So libraries really we're finding ourselves in this very challenging position of wanting our missions on the one hand, demanding that we provide access, and on the other hand, the content distributors really limiting and restricting that access. So one of the ways that we at the Internet Archive, and I am not going to take total credit for this. This is actually Michelle Wu's idea. She is the godmother of the whole idea of what we call controlled digital lending. But the idea of this is that libraries can take the collections of materials they already own, right? So the books, the other materials that have been legally acquired either through purchase or donation or other means, digitize those materials and then make them available to users in lieu of the physical material, right? So lending out a book to one reader at a time, using, controversially maybe to some people, DRM, to make sure that we are mirroring the scarcity of the traditional library lending model. So that's something that Michelle conceptualized academically and worked with the Internet Archive over the years to develop an actual real working program where you can go to the Internet Archive. Lots of other libraries are doing this as well. And you can check out a book that is not available at all in any digital form because we have digitized it and made it available in that way. So that's something that we at the Internet Archive and other libraries have been doing, and that solves that sort of backward-looking problem of materials that we already own, that we've been able to own in the physical world. But it really doesn't provide us a solution for the materials that are born digital. And Amazon or others, Netflix and so on, are not making available to libraries at all, right? That might require breaching a terms of service or breaking some DRM. And that's not something libraries are interested in doing. Libraries are rule followers. Libraries are generally pretty risk averse. And so this has really put libraries in a pretty serious bind. And I think without, legal or policy intervention in this area, I personally really do worry about the role of libraries in this ability to provide access to digital materials in the future.
So I just want to jump in very briefly and say, wearing my other hat, which is the former law library director, I will agree with Lila that libraries are generally risk averse. I will say the pandemic may have changed that. So the pandemic, I think, made a lot of libraries realize that their fear of risk had put their communities and their access to information at risk during the pandemic. So there may be more that are willing to push that envelope now than there were before.
I actually think that is exactly correct. We saw our numbers of libraries participating in our Open Libraries program, I think, double over the last year.
Oh, I would love to see more risk-taking and daring behavior from libraries. So a lot of what we talked about here, though, so far has been about, okay, we took books and we scanned them or we made ebooks, we took CDs, made some MP3s, right? But it's, the same kinds of works. They're basically consumptive uses for the most part. I want to read a book, I want to listen to music. But there's more. So digital technology allows entirely new kinds of uses of work. And I'm gonna send this over to the innovation guy on the panel here, which is Michael Weinberg, with two questions. So one, how does copyright law deal with things like machine learning, right? If I throw 1 million books at some convolutional neural network or whatever the terminology is, and it learns something, is that like a derivative work? Like, do you have to license that work? Do you need permission? Have you made copies? And is the model itself that is created a derivative work? So that's one thing. And then I suppose the other question is like, okay, digital files, like, so I know you've done a lot on 3D printing, for instance, and I think we understand that 3D printed works can be protected by copyright as, say, sculptures or something along those lines. But like, is the file that is a set of instructions for the 3D printer a copy of the printed work or not? Because if it's not, then there are no copyright, it's just, there's no copyright interest at all, but maybe it is. I don't know. That seems like a very hard question. I'm wondering if you could sort of tackle those sort of, those little logic problems I've set out for you.
Yeah, always happy to tackle logic problems. So yeah, I mean, I think at a high level, one of the things that I think people who are, have all sorts of different relationships with copyright law and copyright policy will agree on is that there is a strength of copyright law that it is a reasonably flexible doctrine. And that it does at least have the capacity to take a new idea and a new use and try and internalize it to existing law and case law. In some ways that's a strength. In some ways it's a sort of necessity because we haven't seen significant updates to the Copyright Act in so many years that things would really grind to a halt. That was not the case. And I think sometimes you can look at that and say there are plenty of high-profile examples. I mean, you mentioned some of them at the beginning of a new use coming into the world and it being litigated to some level, sometimes all the way to the Supreme Court, and ultimately finding that that use is accommodated within copyright law. And that's really, I mean, those are encouraging examples, right? It's good that those sort of, thinking about litigation around non-consumptive uses of for search engines or for machine learning, like those have generally kind of gone in a direction that feels like it's enabling new types of innovation. At the same time, it's a really biased sample set, right? Because those are the cases that have an economic engine behind them that allows for that litigation. And courts are not policymakers. And so they're looking at the question in a specific context and don't look at questions that aren't pushed in front of them. And so there's this, I mean, this is a kind of classic public knowledge problem, right? Where when you're thinking about new innovative uses, you often don't have a large kind of economic entity or a bunch of people at the beginning saying, no, this is going to be really important. we really need to figure it out, right? This is a role that public knowledge has historically played over the years to say, well, there's not a constituency for this yet that is big enough to fund a giant lawsuit or to be able to sort of hold a big rally in Washington, but it's really something that is going to be important. And we need to find a way to accommodate it. We can talk about the kind of digital files represented in physical things and how to unpack that. That's another example. I could talk about that for hours, but it's another example of a kind of nuanced understanding of the facts that you need before you apply copyright doctrines to it, right? If you are really thinking through a question like, does a digital file that represents a physical thing in itself as the file represent a copyrightable object, or could it represent infringement? You need to kind of unpack what is the thing, what is the file, what is the nature of the file, how does it relate to the original object or the new object, and then apply copyright law to all of that. That's the kind of thing where sometimes courts are good at that. Sometimes policymakers try to be good at that. And having people in the room who are willing to step back and say, let's just analyze the facts without a real economic interest in the outcome, even if there's a policy interest in the outcome, it can become incredibly useful. I do want to kind of touch quickly on one thing that's come up a couple of times. Is this sort of like balance shifting when you move from the physical world to the digital world. This actually happens sort of both ways. But one of the things that we've seen, this is a good example of sort of courts are not policymakers, right? I mean, it is completely legally defensible on a one-off basis to say, instead of selling this good, I'm going to lease it to you. Leases are well recognized in US common law, like it's a concept everyone's familiar with. And one at a time, it all makes sense. But you step back 10, 15, 20 years later, and you realize what was once a balance where the costs and benefits between content creators and content users, however you want to define those things, were kind of equally-ish distributed, all of a sudden you've kind of realigned things where many of the benefits are on the side of the distributors, the large rights holders often, and many of the costs have been shifted to the users, right, to the public. And I mean, that's the kind of thing that's hard to deal with in court, but you think about it from a policy standpoint, there are other cases where we make people make a choice between leasing and ownership, and those choices have real impacts, right? So you think about, like, I think the easiest example is a kind of warranty of habitability, right? If you own a house, you can choose to lease it to someone, and there's a lot of benefits associated with that, but that comes with an obligation to maintain the house and like to keep having a relationship to keep the house going as a usable thing. And the upside is you get to keep the house, right? But the downside is you have an obligation to keep maintaining it. The alternative is if you don't want to deal with maintaining the house, you just sell the house and you wash your hands of it. And I think that you could, I mean, conceptually that could be a kind of thing where through policy, you could say to rights holders, look, you've got a choice, right? If you want to lease these goods, that's fine, but you have an obligation, right? In the case of software, maybe that means a perpetual obligation to patch security vulnerabilities. In the case of media, it means a perpetual obligation to make it usable by up-to-date software. And it may be worth it on balance for you to work within those boundaries because the lease is still a better option for you. But if you want to wash your hands of those ongoing obligations that we think of in the context of a lease, then you sell it. And then you don't have to deal with those obligations. But without a kind of policy intervention along those lines, you get kind of both benefits of saying, I have no obligation to maintain these or keep it going or anything like that. And I get to keep control of it to the extent that I want, and it's beneficial for me to do so.
Oh yeah, that is absolutely a fantastic point. I mean, when you lease a car, people who lease cars, maybe they're spending a little more month to month and they don't have all the benefits of ownership, but they can give the car back and get a lot of money, right? It's not like they bought a car and it's like, yeah, you don't really own it, you can't resell it, but also we're not going to take it back or give you your money back, and we're going to charge you the same that we've always charged you. It's like, well, no, you don't just get to change. Yeah, that's a great point. So one of the laws that can sort of get in the way of these sort of common sense approaches is the earlier mentioned DMCA, in particular, the anti-circumvention provisions, section 1201. One of the things I'm supposed to remember to do, of course, is to promote public knowledge's work. So yes, I mentioned the Kurtzsang case. Public Knowledge filed a brief in the Kurtzsang case. We did not file an amicus brief in the Bobbs-Merrill case in the early 20th century, but we do participate frequently in the 1201 proceedings at the Copyright Office, and I'll just explain them. These aren't things I'm going to throw to the panel. So that's basically, you're not allowed to circumvent DRM to access a work, but the Copyright Office is empowered to grant exemptions to that for particular uses. This year, a new public knowledge attorney, Kathleen Burke, testified at the Copyright Office, and we submitted testimony saying that, well, people ought to be able to, bypass whatever technological locks are in place that prevent them from repairing video game consoles, because that saves them money, lets them continue playing their old games. Seems common sense, yet it's very controversial. In other areas, someone wants to bypass the DRM on, say, automotive software. One of the reasons why the Copyright Office might deny that request is not to protect the copyright type interests of the automotive software itself. The fear isn't people are going to take out the automotive software on this Honda and put it up on the Pirate Bay, and then people will get free copies of automotive software. It's like, it's useless if you don't have the car anyway. Like, they're getting money from the car. But instead, other business interests, like maybe they don't want you to unlock a particular feature that they want to have in the car, but you have to pay to get it. And one of the reasons the Copyright Office might deny is to say, well, maybe it would be a danger to public safety if people were able to modify and you just talked about how courts aren't policymakers, yet the Copyright Office is in this role of of setting policy on things like public safety in relating to agriculture and automotive and avionics that seem to have very little connection to copyright. And I was just wondering if anyone wanted to reflect on this system and perhaps, propose if we maybe need to rethink any of the procedures under which it operates.
As someone who's played in this system a number of times in a number of ways, I mean, on one hand, I think you could point to this 1201 system as a success in the sense that it is a place where the public has been able to organize to get exemptions for things. But I think also that that's like a completely short-sighted way of viewing the system. I mean, for example, I've been helping with a 3D printer related exemption for the last couple of cycles. And it was so you could use whatever material you wanted in a 3D printer. You didn't have to buy it from the manufacturer. And the first round of objections were like, this could create problems for if 3D printers are used to create airplane parts. And it's like the Copyright Office has no competency to evaluate that question. And like, that's not a copyright question. If that's a problem, the FAA can step in. But the idea of leveraging copyright to deal with that is just like a bunch of people who don't know what they're talking about, including me, fighting about an issue they don't know what's going on. And I think more importantly, like the entire conception of the process is a lot out of whack, right? So the entire system, first of all, assumes the existence of a deep public interest community that can get together to organize on the side of various people asking for exemptions. It also, and then puts the government, that is a publicly funded entity, and it provides the funding for that side. And it puts the government, which is a representative of all of the people, in a position of sort of trying to arbitrate between usually a large economic stakeholder and some sort of public interest organization. It also kind of assumes that every one of the disputes that's going through the process reduces them to an economic fight, because you have a large rights holder that's paying a bunch of money to fight it. And so you need a kind of economic angle to rally people around on the kind of pro-exemption side. But I mean, I can tell you a story about why using your own material in a 3D printer is a primarily an economic issue. But I mean, fundamentally, it's not. It's just a kind of, it's a freedom to use your stuff issue. And that doesn't necessarily come with like a huge number of people who are willing to pay to do it, but it doesn't make it an illegitimate concern. I mean, there are plenty of examples of other exemptions where people are trying to break DRM on DVDs to like make their own, to do commentary or things like that. There are versions of that are economic, but a lot of them are expressive. And to sort of say to that expressive use, you need to find an economic way to fund the request, where you're then going to, where your government then is going to sort of sit in judgment and balance between what you're doing and someone in the industry who created who controls the rights. It's a completely distorted process that really doesn't seem to lend itself towards a wide range of just outcomes.
So, Professor Mtima, yeah, I was hoping to get your input on this question, because it seems like you're interested in sort of the rights of smaller creators in particular, and it seems like the discussions that happen in this 1201 process at the Copyright Office are very disconnected from that aspect of what I thought was the fundamental purpose of copyright law. Yeah.
Now, and the reason, one of the things that really prompted me to want to, even before you asked the question, was that I really appreciated Michael's observations and insights, because in my work, I have emphasized that we have for a long time had a problem in copyright and IP in general in terms of overemphasizing only the economic interest and only the economic perspective. In my work, I have argued for many years now for a social justice perspective towards these issues, which some people misunderstand and think that it just means, some sort of like crazy leftist blow up the whole system. But that's not really what it's all about. It's just simply saying that when you think about the role of intellectual property and intellectual property protection in the total political economy, it covers a range of needs and impacts and interests because you're talking about access to health. You're talking about the advancement of our culture. You're talking about technological innovation. To look at all of that and to look at it only in terms of an economic perspective is leaving a lot on the table. And so I think that what Michael was suggesting is that we need to not only look at this stuff through an economic lens, and to pick up on some of the things that both Michelle and Lila were saying. I think that libraries is a perfect example of this, right? I think one of the things that we definitely have to do that we clearly did not do, for example, in constructing the DMCA, was we didn't really give any real thought to library functions, right? In fact, if you look at the way the DMCA is structured, which kind of, if one looks at the history of where that came about, I mean, it grew out of what I call like the pre-DMCA, copyright wars. It grew out of, just as Michael was describing, a very limited context, right? You had these lawsuits with entities like, strangely enough, Playboy and the Church of Scientology on one side, interesting partners, but whatever, and suing, people because of unauthorized uploading, of their material. And, the DMCA grew out of just focusing in on this conflict as if it was simply a DeAndreas conflict, that it's like, okay, let's look at copyright owners, let's look at internet purveyors, and we're gonna just sort of try to allocate responsibility between you two guys, and you guys will solve the problem. And what was missing from that was not a thought about, was actually there's a third constituency in the room, right? It's called the public, okay? And the public, we have to think about them and their interests, and we have to think about them both from the perspective of rights and responsibilities, right? And the fact of the matter is that the DMCA just really doesn't talk about that, doesn't consider that. And so we're left to this economic combatant resolution, which is sort of a skewered perspective of what the entire topography is. So I think that we're kind of really at a point now that I would argue that almost everybody, like all constituents, have a major gripe with the current landscape, and are saying that, okay, each of the three legs of the stool could each come up with a great argument to say, we need to revisit this, right? And here's something that I think you've not thought about, and I would like you to think about that. And from that perspective, maybe it is time for us to have a conversation, a policy conversation, revisiting these issues and figuring out, now that we have 20 years of growth and retrospective with us, to now figure out, okay, is the system working the way that it ought to work? And if not, what do we need to do now?
Yeah, I think that's a really great observation, that there's really no constituency that is particularly happy with the status quo. Just the issue being, can the different constituencies find a way to agree on ways to fix it that they're all happy with, or are there, what sort of trade-offs and compromises and deals have to be made? Because I view everything from the user perspective, but I understand reality. Deals are possible. It's just sometimes people don't want to give an inch, because it doesn't do any good. It doesn't do any good to make a concession when there's no chance of getting a concession returned, because then that becomes your baseline. So you have a lot of problems. But I know Michelle has things to say on this general topic, so I'd like to throw it over to her.
So I would chime in and say, I think what we have been pushing, and this is what underlines the whole theory of CDL, is that the public interest is greatly served by the libraries, and the cost that will be paid by the public if libraries don't have the right to preserve works will be extreme and will last for many, many years going forward. So just think about historians who cannot verify information because libraries were not able to preserve information, whether due to license agreements or non-circumvention, right? So the costs are significant. And I think that's one of the reasons why we came up with CDL, because right now in a world where we have the chance to still buy things in physical format, it allows us to at least convert that into a digital format for use purposes and also to preserve it because we retain the ownership rights.
So one of the sort of premises of CDL, and I've seen versions of this argument in other contexts, is like, look, we're going to do something with digital files that very closely emulates what we did with physical copies of things. And, you know, there's much more to the argument than that. You've actually got to walk through the case law and the 4 factors of fair use. But that's basically the strongest reason, I think, that to say that something is a fair use, you know, from a very high level policy perspective, because that it's nothing new and it's what's already happened and it's happened for a long time. But that doesn't actually necessarily convince every judge out there, and the law is complicated, right? So while I strongly believe that CDL is a fair use, you know, what happens if there is a judge out there who says, no, it's not, this is a profound change, how does the library community react to that? And you know, how should they react to that in your opinion? And obviously I would love to hear Lila's take on this as well.
Sure, so this is a particularly hard question to answer, partly because I think CDL is it's just common sense to me. But aside from that, trying to figure out the strategy if a judge comes down and says that, okay, this is infringement, it's not fair use, really depends on the court's reasoning. Because with a lot of fair use cases where you're dealing with technology, if you read through the cases, you can actually see a path to keep the concept and just revise how it's implemented. So I think that's the first step, is just take a look at the court case, look at the reasoning. Is there a way to keep CDL but just redesign how it's done? The second approach is much more challenging because it does actually require libraries to be willing to take a lot of risk. And that is challenging license agreements directly, where we think that they are inequitable and undermine the public interest that was intended by the Copyright Act. And there are any number of ways to do this. I know there are already antitrust efforts to challenge differential pricing, where in the print world, a library and an individual would pay exactly the same price for that book, whereas with licensing, libraries will pay significantly more. Also, in instances where the preservation right is eliminated, essentially, there's no ability to eliminate, there's no ability to preserve or to do interlibrary loan. I think that there are possibilities, probably as controversial, if not more controversial than CDL, where libraries could challenge license provisions based on preemption, based on antitrust, based on misuse, and based on just unconscionability, but would be very, very targeted to the purpose of copyright, the unique role of libraries in preservation and access. And it would have to be, I mean, all of those would be as challenging as trying to defend CDL.
Lila?
Sure. So I guess, like Michelle, I feel CDL is so just reasonable on its face that surely a court will agree with this. And if we look at the pattern of publishers and authors suing libraries for their common sense use of technology, so far libraries have won. They've won every single one of those cases. So hopefully this comes out that same way, and we are fighting really hard to make sure that happens in the case against the Internet Archive for our controlled digital lending program. The other, so Michelle raised a lot of really interesting ideas. I mean, look, this whole fight could be completely taken off the table if Congress decided to just support controlled digital lending in a really obvious way, either by updating the Copyright Act or by passing some kind of a resolution or something to sort of give an indication to the court that look, this is common sense. This, as a policy matter, this is something that Congress supports, right? So one can imagine a number of, even at the state level, but I think really at the federal level probably would have to be, of policy interventions that could prevent 10 years and millions of dollars, going down the drain fighting this fight, and just end up with laws on the books that codify controlled digital lending, kind of like there's laws on the books codifying interlibrary loan, which was a practice that libraries had done for decades and decades. And Congress just wanted to make it clear, like, yep, that's okay. We think that's a good idea. So that's another way to go. I actually think that's probably at the end of the day harder than winning the court case, because our Congress is what it is right now. It's pretty hard to get anything done. On the other hand, the Music Modernization Act happened. It got passed, and it was a compromise. There is, I will say that there is hope. I know a lot of folks that have been sort of fighting the copyright wars for a long time feel very beaten down by it. But I think the Music Modernization Act showed, like, look, on the one hand, we want to compensate artists that have been screwed by a system for decades. And on the other hand, we want to also ensure access to materials that are not commercially available or that should have been public domain, a long time ago. We want to ensure access to those things. Let's do them both. And we got that done. And so I would say it is not impossible to change copyright law in a way that actually does satisfy the needs of the public, the needs of authors and creators, and kind of make everybody happy. I know some people are going to think I'm insane for saying that, but I really do have hope. I think this is not actually completely out of step. I think this is doable.
And if I could just tack on to that, I mean, I think that you make a really important point about compromise. I mean, because, the first step is looking at what are the concerns of the other side. And I think some of the complaints about CDL aren't really about CDL as a concept itself. It's really more about, okay, but, it doesn't end up working out that way. What happens when somebody gets access to a copy and then they do things with it that they aren't supposed to do, right? And so the thing of it is that sitting down and trying to figure out, okay, how do we address that part of the equation, right? Because addressing that part of the equation doesn't necessarily mean that we say, well, we do away with CDL altogether, right? I mean, because I could imagine that, for example, if anybody ever was crazy enough to actually want to pay for one of my law review articles, because we don't get paid for that stuff. If I felt that somebody had access to or made extra copies or they shouldn't have it, if the response was, well, okay, let's see if we can figure out how to address that. The only option from my perspective would not be, no, it shouldn't happen, right? I mean, it might be, if I'm interested only in the economic side of it, I might say, well, okay, if you can figure out a way that my economic interest can somehow be accounted for in that, maybe I might not have so much of a problem with it. So again, I'm not saying that that's the only response, but I think that this comes back to, we need to sit down and just accept realistically that the way in which people engage with expressive works in the digital world is just simply different from the way that we did in the analog world. And to expect that people will engage with expressive works the way that we need people to do so, okay, and to just lock ourselves into the premise that they're going to get a copy, they're going to open it, they're going to look at it, then they're going to put it back on the shelf, and that's it, okay? That's just not the world that we live in today. And so we need to sit down and accept that we have a new reality and that there are some benefits that flow from that reality. There are benefits that flow, for example, to creators, right? There are new markets that open up, as Michelle explained in connection with Betamax, right? But then there are also new opportunities for the ways in which users, okay, can engage with works that was simply just not possible in an analog world. So I think we need to stop resisting the fact that the future is here, and begin to think about, well, how do we accept that in a realistic way and legislate from there?
I think that is
Amen.
a fantastic way to close out this panel on just sort of looking to the future, and really the need for copyright policy can be quite contentious, more so than really almost any other policy area I work on. And really the different people do need to talk to each other in the spirit of mutual understanding and compromise, or little is ever going to happen. You know, there's a huge list of questions I have when I got to like 1% of them as expected. There's so many issues, so I will just promote public knowledge at the end if anyone else has anything to say. But, you know, we're going to continue public knowledge. We're going to continue to work on this, not only the rights of users to like own and resell things, but also right to repair, making sure that copyright claims don't prevent people from like reselling phones and cars, and just like any number of issues, as well as the rights of libraries. And you know, stay tuned for our next panel, which just the graphic was just up and I was going to say its name and it went away. But there we go. Promoting the open internet through public knowledge's history, May 2021, net neutrality. I probably will not be moderating that one, but another key issue area for public knowledge. So thank you, everyone, and especially thank you, panelists. I will applaud.
Thanks,
There's no applause at the end, but
Thank you.
take care, everyone.